Our panel tonight is called Strengthening Legislation and Policy to Protect Cultural Heritage. So we've been talking about international repatriation all day today. We're going to continue talking about international repatriation here, but we're going to start pulling it out and talking about the things that we need to do to better our future in repatriation, including international as well as domestic repatriation efforts. So let me turn this over. We're going to have some brief introductions, and then Katie's going to get us started off here. So Jamie, would you like to introduce yourself?
Sure. Hello, everyone. My name is Jamie Meuwissen. I'm a senior analyst with the Government Accountability Office. I'll explain a little bit more about our organization and what we do after Katie speaks and gives her presentation. But we are a research arm of Congress, and I have worked on a couple of jobs in this area, and wanted to thank Shannon and AAIA for having us back.
Hi, everyone. It is an honor to be with you tonight. It's great to spend some time with you. My name is Katie Klass, and I am a partner at Hobbs, Straus, Dean & Walker, a firm based in Washington, D.C. And I'm also a citizen of the Wyandotte Nation. So I'm going to try to share my slides with you. We'll see how this goes. Give me 1 second. Can you see it?
Yep.
Good. Okay. So what we're going to do is we're going to start this panel by talking about a case study where a client that I work with, the Pueblo of Acoma, dealt with a situation dealing with international trafficking of a sacred shield and really identified holes in domestic United States federal law. And what Acoma did at that point to address those holes. I want to highlight before we dive in that we're going to be talking about some NAGPRA and ARPA existing domestic federal law and sort of walking through the basics of those statutes. And it's important to note that they have a lot of holes and problems in the way that they operate domestically. That's not going to be the focus of what I talk about, but I do want to acknowledge up front that what we're working on here with Acoma does not address the whole picture, and that needs to happen. Okay, first, and I know that this is going to be a refresher for many of you, but I think it's important to just walk through what NAGPRA and ARPA do domestically before we start talking about what they don't do internationally. So NAGPRA really... certain things have to happen for NAGPRA to prevent a tribal cultural heritage item from being trafficked and for a tribe to be able to secure its return. First, the tribe has to be culturally connected with the item. Second, it has to qualify as a cultural item under NAGPRA, which really requires examining its cultural significance and relevancy against that statutory definition. And then third, the item needs to satisfy the provenance requirements of NAGPRA. It needs to be removed from land that's protected by NAGPRA within sort of the time frame protected by NAGPRA. What is a cultural item under NAGPRA? There are, of course, categories, and each category has its own definition. Cultural patrimony, I feel like that's the category that I spend a lot of my time talking about. It includes objects that have ongoing historical, traditional, or cultural importance, and they're so important to a community that they're considered inalienable. They're communally owned. It's important to keep in mind that there's case law that says that it's appropriate to consult tribal experts when you're determining whether or not a particular item is cultural patrimony. Next, we have sacred objects, and that includes ceremonial objects that are needed by a traditional Native American religious leader for practicing Native American religions in present day. Then you have human remains, associated funerary objects, and unassociated funerary objects. When we talk about NAGPRA's provenance requirements, when we talk about the land piece, that means that NAGPRA really applies to items that are taken from federal or tribal land. And the timing piece means that even when you're talking about NAGPRA's trafficking prohibitions, they only apply when you have an item that was removed in violation of NAGPRA. And so NAGPRA is limited such that an item has to have been removed from federal or tribal land after NAGPRA's 1990 enactment date. And that is a big hole I think many of us have identified in NAGPRA. Next, we have ARPA. ARPA is really useful when you're talking about trafficking and preventing trafficking, but I think it's important to acknowledge that ARPA is, it's older than NAGPRA. It's not designed to address Native American tribal cultural heritage items in the same way that NAGPRA is. So it can be a little bit clunky, but it has flexibilities that make it really important. So for you to argue that ARPA prevents a particular tribal cultural heritage item from being trafficked, again, you really need to you need to establish certain elements. One, if you're seeking return, if a tribe is seeking return of that item, it needs to have a cultural connection. Two, that item needs to qualify under the definition of archaeological resource, which again, you're looking at its archaeological significance and its age against the definition. And then third, it needs to satisfy the provenance requirements of ARPA. ARPA was enacted in 1979, so it's a little bit older than NAGPRA. So it's easier to establish that something was removed in violation of ARPA because it goes back further in time. But it's also more flexible in that you can have an item removed under another federal law or a state law, and we'll talk about that more in a minute. The definition of archaeological resource, there's a specific definition in ARPA, and it's defined to include material remains of past human life or activities that are of archaeological interest and are at least 100 years old. Again, important to acknowledge that that is by no means a definition that acknowledges the ongoing practices of tribes today. ARPA's provenance requirements, the land that it applies to, meaning items removed from public land or Indian land, are covered by ARPA. And the timing requirements of ARPA are a little bit more flexible, as I said. ARPA prohibits trafficking of items that were removed in violation of ARPA, meaning after ARPA's 1979 enactment date. But it also has this sort of more flexible, I kind of think of it as a backdoor trafficking prohibition, where if you have an item that qualifies as an archaeological resource and it was removed before ARPA was enacted, but that removal was itself in violation of a different federal law, a state or a local law, then ARPA prohibits it from being trafficked today. And that's really, really useful when you're establishing that something is protected today. So let's talk a little bit about why NAGPRA and ARPA, as they currently exist, did not help with the Acoma Shield situation. There we had a sacred shield that Acoma knew had been stolen from its caretaker that showed up in an online auction catalog for an auction to take place in Paris, France, in May of 2016. And so Acoma really, it had very little time, a couple days before the auction was set to take place. And Acoma reached out to federal officials, other tribes, the public. Really, the auction house itself really called on the auction house to pull that shield from the catalog. And it did. We didn't know it was going to happen until literally the auction, and the shield came up and it had been pulled. And it was something huge to celebrate. But that began really the years-long process of actually bringing the shield home. Acoma learned through that process that it's pretty difficult to navigate across all of the federal agencies whose jurisdiction touches on international trafficking of tribal cultural heritage items. There's not really one centralized point of contact, and that can really slow you down when you have 2 days to stop the auction. But they successfully did coordinate with state and DOI and DOJ, and eventually DOJ initiated an in rem case, meaning the case was actually against the shield. We didn't know who within the United States was claiming ownership of the shield. So the case was actually against the shield itself, seeking return of the shield. And through that litigation, which was in a United States federal court, DOJ secured a warrant for the shield's return. And DOJ argued in that litigation that the shield had been originally taken from Acoma in violation of the Antiquities Act, because it happened in the 70s before ARPA was enacted, that it qualified as an archaeological resource under ARPA, and that therefore its trafficking today was prohibited by ARPA. So they got creative. They used the laws they had to establish that at least domestically, it was illegal to traffic the shield. The State Department then used that warrant to request mutual legal assistance, which is sort of an international tool that one country can use to ask another country for help in a situation like that. But France said that without having an explicit export prohibition in domestic law and an accompanying export certification system, they would not facilitate return. So that's when Acoma really said, what can we do? This is not right. What can we do to strengthen the law to make this never happen again? And so at that point, we really started digging into why. Well, what is the shortcoming here? What's happening that we have this we have this warrant, we have this mutual aid assistance, we have everything in place. Why can't we get the shield back home? And the reason is because there is a 1970 international treaty to which both France and the United States signed on that actually creates all the mechanisms that we would have needed to ask France for assistance. But the United States just hasn't done the things it needs to do in its own domestic law to trigger everything under the UNESCO Convention. So we set out to fix that. So the UNESCO Convention, it's really designed, they use the term cultural property, but it's designed to, and it has a specific definition of cultural property, just like every other statute. It's really designed to allow states to call on each other for help. It's important to keep in mind that under the UNESCO Convention, the state party that's asking for help, technically under the convention, that cultural property that's originating from within its borders belongs to it. So in tapping into the UNESCO Convention, tribes are having to sort of work through the United States as the owner of the cultural property for purposes of the return. Under Article 6 and 8 of the UNESCO Convention, it lays out what a country needs to do in order to be able to use the UNESCO Convention to get its own cultural property back from another country. And it says that you need to introduce a certificate specifying the cultural property that can and cannot be exported, prohibit the export when it's not done in compliance with that certificate requirement, publicize the prohibition, and impose penalties. And so that's what we're missing. That's what we're missing in domestic law. That's why when we know something is illegal domestically, it's very hard to then go and say to another country, give our cultural property back. And so on the flip side, if we did have these things in place, we could have called on France to act under Article 9 of the UNESCO Convention to help us. And that article calls on countries to help each other. And it says that you can ask for a concerted international effort to carry out necessary and concrete measures that may include control of exports and imports via agreement. So if we had done these things, we could have gone to France and asked for this help under Article 9. The funny thing is that the United States has actually implemented the other side of the UNESCO Convention for many years. We have the Convention on Cultural Property Implementation Act in place, where other countries can come to the United States and ask us for help in protecting their cultural property. And so that implements Article 9 of the UNESCO Convention. And what it looks like is other countries come to us and they ask for what we call a bilateral agreement. We negotiate that with them, and then we publish it in the Federal Register. And then once we have a bilateral agreement with another country, import of covered cultural property is prohibited unless there's a certificate, and we can seize and facilitate forfeiture of that cultural property, so we can help other countries get their cultural property back. So we've already got all of that in place for other countries, but we haven't done the same for our own cultural property and that of tribes. So that is the STOP Act. ACMA has been working for years to get the STOP Act enacted, and really it's designed to put in place domestically what we need to marry NAGPRA and ARPA with the UNESCO Convention, so that what is already prohibited domestically is also prohibited and we can get things back internationally. The STOP Act explicitly prohibits export of any NAGPRA cultural item or ARPA archaeological resource that itself is already prevented from being trafficked domestically under those federal laws or another federal law. NAGPRA cultural items and ARPA archaeological resources, in order to be exported, an exporter needs to go get a certificate from the Department of the Interior. And so those two pieces together really are what's missing to be able to use the UNESCO Convention. But also the export certification system will track what is leaving the United States and will give tribes the opportunity to see what's leaving for the first time, which is huge in and of itself. And the STOP Act also confirms the president's authority to enter into these agreements with other countries under the UNESCO Convention and other international mechanisms. And then on top of that, the STOP Act facilitates more coordination between the federal agencies and also input from tribes. And it also puts in place a voluntary return framework where if you have an item that might not meet the strict provenance requirements of NAGPRA or ARPA, but you want to return it back to its home tribal community, there's a framework where you can find out, the appropriate tribe to return it to. And then last, it increases NAGPRA penalties. Last December, we got very, very, very close to passage, so close. The STOP Act passed the Senate via hotline and unanimous consent, which is a big deal because it means that any senator could have prevented passage and they didn't. We had House committee sign off, and then at the very last minute, House Ways and Means had technical questions, and it was very close to the end of Congress, and we just ran out of time. But it was really heartening to see so many tribes and tribal organizations, including AAIA, come together in that final push, really to reach out to House leadership to push for passage. So as sad as it was that we didn't get across the finish line, it was really nice to see everybody come together. The STOP Act has already been reintroduced in the new Congress, and it's cruising along. It's doing really well. It was introduced in April of 2021. Its main champions are Senator Heinrich of New Mexico and Representative Ledger Fernandez of New Mexico, but we also have sort of a unique pairing with the Alaska congressional delegation because this is such an important issue in Alaska too. And it really helps highlight how bipartisan this issue is. We've been focusing on moving the House version, and the bill has already had a hearing and been favorably marked up before the House Natural Resources Committee. And in October, it was actually reported out of that committee on unanimous consent. So it maintained its bipartisan support. So it's great. It's exciting. We're hoping for addition to the House suspension calendar after Thanksgiving. And all signs point to we're moving ahead pretty smoothly. And that is in large part thanks to the support from Indian country. So thank you so much. All right, that's it from me. Thanks, guys.
All right. Good evening, everybody. Shannon, I just want to check in. Did you want to do anything between Katie and I, or should I just go forward?
Well, I did see that there was a question in the chat. Happy to go ahead and answer that if we'd like. Is that okay, Jamie?
Sure, absolutely.
All right, Katie, you're back on. Melanie is asking,
Melanie.
what is a source that you referenced on the consultation requirement for sacred objects? I believe it was in your PowerPoint.
Yeah, I can send you that case law. There's a couple cases that go over that concept, so I'll send it to you.
Can you remind us exactly what point that was?
Yeah, just the concept that that consultation, it's appropriate for police officers, prosecutors to talk to and consult with tribal experts when they're determining whether a particular item is cultural patrimony. I think it's the Tidwell case, but I'll send it to you, Melanie.
Beautiful. Thank you. All right, Jamie, you're on.
All right, super. So let me see if I can go ahead and get my slide deck up here. All right, how does that look for everybody? Okay, super. I got a thumbs up from Katie. So if you want it to go full screen, I believe everyone has on their individual displays full screen box up in the upper right corner of your slide. So if you want it larger, feel free to do that. So I introduced myself earlier as a senior analyst with the Government Accountability Office. We are located, headquartered in Washington, D.C. We do have field offices across the country. And like many others right now, I believe that most, if not all of us, are working from remote locations due to the pandemic. But typically, I am headquartered in Washington. We are an independent, nonpartisan federal agency, and our mission is to support the Congress in meeting its constitutional responsibilities and to help improve the performance and ensure the accountability of the federal government for the benefit of the American people. What does that mean? So typically, we get requests from congressional committees or subcommittees, sometimes members, individual members, and we support congressional oversight by auditing federal agency operations, so executive branch agency operations, to determine whether federal funds are being spent efficiently and effectively. We investigate allegations of illegal and improper activities, and we report on the extent to which government programs and policies are meeting their objectives. So basically, in a nutshell, we do a lot of programmatic auditing. We do have a financial audit team, and we have a special investigation team. But by and large, most of us are conduct program audits of federal agency programs. So in that context, what was the congressional interest that generated our work? So in December 2016, Congress noticed that tribal cultural items continued to be removed from the possession of Native Americans and sold in violation of federal and tribal laws. And they actually passed a resolution that condemned the theft, illegal possession, or sale, transfer, and export of those items. And around the same time, they requested that GAO review what federal government or what federal agencies had done or could do to help prevent that removal, as well as the illegal trafficking of those items. And so, in further conversations, when we started this work with Congress, we learned quickly that this was about the time that the Acoma Shield case was happening, and public awareness was very high around this issue, thanks to the efforts of everyone that was involved with that case. And the request that had come in from Congress was very broad. So they wanted us to look at NAGPRA. They wanted us to look at domestic excavations, theft and damage. They wanted us to look at the international aspect. So we tried to pinpoint what their highest priority was at the time. And they decided that because of everything going on with the Acoma Shield case, They really wanted us to focus on what we termed international repatriation, as a short title for our first engagement. So that was the first piece of work that we did, and then subsequently, to satisfy another portion of the request, we looked at the domestic issues associated with federal agencies' efforts to help protect these items. So you can see on the left slide, that's our 2018 report on international patriation. And on the right is the cover page from our 2021 report that focused on more domestic issues. So I wanted to talk just a little bit about, give a kind of an overview of each of those pieces of work. And I'm going to try not to trip over things that Katie has already talked about because we did have some overlap. But on the international repatriation job, our two objectives were one, to look at the actions federal agencies had taken to assist tribes in repatriating their items that were being auctioned overseas, and two, to take a look at the laws addressing the export, theft, and trafficking of Native American cultural items, which is a term that we developed to sort of encompass, and we defined it in the report, to encompass both items covered under NAGPRA and Native items that would be covered under ARPA's definitions also. And then also challenges that federal agencies and tribes are facing at the time in proving that those that there were violations of those laws. So what did we find in those related to those objectives? So on the federal agency action side, we actually found that agencies were conducting efforts to help tribes when tribes would reach out to them. They tended to be more ad hoc, and as Katie said, there was no single point of contact, and so there were folks that were helping, but it was sometimes difficult to navigate who to talk to. And when, like she highlighted in the Acoma case, when you find out that something is going to auction in 2 days or maybe 6 hours or whatever, it's really difficult to get the kind of assistance that you might need to secure or leverage in that short period of time. But federal agencies were conducting listening sessions and consultations at regional and national meetings. They were doing some monitoring of foreign auctions and trying to communicate with tribes about the auction catalogs that were containing potentially questionable items. They were facilitating communication and arranging meetings with foreign entities, particularly in the case of the Acoma Shield. They conducted media outreach to raise public awareness around the issue. And they had established an informal staff level interagency working group. But like I said, that working group at the time was more ad hoc, sort of on a needs basis around this particular issue. They didn't have clearly defined outcomes or objectives or a mechanism to monitor or report on its progress in achieving those objectives. And they hadn't really identified clear roles and responsibilities for the participating agencies. So based on that finding, one of the recommendations that came out of that report from GAO is that the interagency working group actually implement what we've defined in prior work at GAO as selected leading collaboration practices, such as taking those steps to agree on outcomes, like what is our mission, what is our charge, what are we looking to do, define some objectives, clarify the roles and responsibilities of the participating agencies and staff, and document those decisions, right? Take steps to formalize their activities. We also recommended that the agencies identify and externally communicate to tribes points of contact within each agency that would be responsible for responding to tribes' requests for assistance in cases of repatriating cultural items from overseas auctions in particular. We know that a couple of the agencies have already closed the point of contact recommendation, so we're glad to see that. I think there are a couple of others that we're working to follow up with. I think they've made efforts toward implementing those recommendations, and hopefully, we look forward to closing those out over the next calendar year. And as of the end of October, we found out that there is a document being drafted that's got input from the 4 agencies that we looked at in this review, which are the Department of Homeland Security, Department of State, Department of Interior, and Department of Justice, regarding sort of formalizing this group, setting some objectives, establishing roles and responsibilities, and that they plan to engage with the tribes and aim to finalize that documentation, hopefully in the spring. So we look forward to that, keeping an eye on that, and hope that that keeps moving forward. Regarding the second objective, which was to take a look at the laws addressing the export, theft, and trafficking. I don't know that I'll say much more on this. I think Katie covered a lot of the framework that exists and some of the challenges associated with it, particularly with the provenance, right? Being able to prove that an item was taken after the laws came into effect, although ARPA does have that that additional provision that broadens it a bit, and then determining the location of the removal, we have seen is sometimes difficult, and this will come up when I talk in just a minute about the the work that we did looking at domestic theft and damage of cultural items. Just want to take a peek here and want to make sure that I'm not missing anything. So we did make a recommendation actually to federal agencies related to the legal framework that exists. And we recommended that the interagency working group members assess in consultation with Indian tribes whether and how amending the US legal framework governing the export, theft, and trafficking of Native American cultural items would facilitate the repatriation of these items from auctions overseas and report its findings to Congress. So we directed that recommendation at the agencies because we felt like they are uniquely positioned to recognize the challenges that they face, particularly having gone through the Yakima Shield case. And I think what Katie just presented on the STOP Act is headed exactly in that direction. So, we will continue to follow up with the agencies to see what they're doing in response to that recommendation. But it sounds like the proposed legislation goes a long way to addressing some of those challenges in the current legal framework. So that was sort of the highlight of our 2018 report on international repatriation. With regard to the second report that we did, looking back at, I say back, kind of starting with coming back to the domestic universe, our objectives there were, we had 3. We looked at the approaches that federal agencies have taken to help prevent and detect the theft and damage of Native American cultural resources from, particularly from federal lands. We looked at what is known about the number and outcomes of incidents of theft and damage of Native American cultural resources. And we also looked at what factors may hinder agencies' efforts to prevent, investigate, and prosecute those incidents domestically. So regarding federal agency actions to protect items before they're taken or damaged, we found that they take several actions actually. So they conduct public awareness and education programs. They install physical protection measures to limit access to areas where they know those items might exist. They do conduct some site monitoring, both physical monitoring by agency personnel or sometimes trained volunteers, or conduct video surveillance of archaeological sites. And they provide staff training, both to law enforcement and cultural resources staff. Regarding trying to get a handle on the number of known incidents, that was a little bit more challenging. Agencies don't collect data and they don't store their data for the express purpose, first of all, of answering GAO's questions, unfortunately, um, but even for tracking these types of incidents. One of the complexities is the different definitions, right? The way that items are defined under NAGPRA and ARPA. What we wanted to know to answer this question, because in some ways, we didn't care whether it was defined under NAGPRA specifically or ARPA. We wanted to know if this is an item that is important to tribes, or these are, items important to tribes and they're being damaged. We'd like to know if it was an incident, right? So we had to sort of, we asked the agencies to compile the data for us, and they had a difficult time because of the way their law enforcement databases are set up. But doing the best to work around the limitations, um, the agencies provided data that basically gave us a flavor that there are at least hundreds of incidents of theft and damage. And then when we tried to match that up with the prosecution data, we found that there have been fewer than 100 cases that have gone to prosecution. So, and we also understood from the agencies that their data might not capture the full extent of incidents involving theft and damage of those resources, sometimes in part because they're not finding them, because they're in areas that are more remote, and they're not even being reported, but also because they may have missed it in their database. It may have been coded as something different, and they weren't able to pull it and capture it to be able to report it to us. So it does have some caveats. Regarding the prosecutions, like I said, there were fewer than 100 cases that have been prosecuted and I should qualify, we looked at the fiscal year 2009 to 2018 time period. So there 45 cases resulted in guilty pleas and sentencing. There was one case that went to trial, and the defendant was found not guilty, and there were actually 18 declinations, mainly for insufficient evidence. So again, that sort of goes back to the points that Katie raised earlier about sometimes there's just not enough information to pursue legal action based on the way that the laws are set up. And then our final objective in that report was to look at factors that hinder agencies' efforts to conduct prevention, investigation, and prosecution activities. And we found that there were three primary reasons or factors that hinder their efforts. The first being resource constraints, the second being competing agency priorities, and the third being limitations with data to support their decision making. So as I'm sure everyone's familiar, we all deal with resource constraints and also competing agency priorities, but we directed a recommendation to the agencies to deal with the limitations on their data because we felt like with better data about these incidents and their occurrences and their locations, they could better prioritize the constrained resources that they have potentially with that information, and also use it to inform priorities within the agency. If you don't know what you don't know, it's really hard to make a business case for putting resources into a particular activity when everybody's competing for an already limited pot of resources, both in terms of staff and funding. So our recommendation there was for the agencies to develop a plan in consultation with the departmental consulting archaeologist to identify and respond to the risks posed by those factors that I mentioned that hinder their efforts to prevent and investigate incidents of theft and damage of Native American resources. And that's a newer report, so we don't have a lot of information about what the agencies have done yet. I know they have been in conversations about looking toward what they might do to implement that recommendation, and so I look forward to following up with them to see where those conversations have taken them. And I failed to advance my slides, but these are the main findings that we had in each of the reports. So these are 3 sort of headlines from the International Repatriation Report. And then our, getting a little ahead of myself here, and the 3 headlines from our theft and damage report. And so in preparation for our conversation tonight, Shannon also asked if I would just touch on our way back work on NAGPRA. So this is work that GAO conducted back in 2010 and 2011 when NAGPRA was about 20 years old. And I won't say a whole lot only because I'm not as familiar with this. The work, it sort of predated my time in this area, but we split it into 2 jobs again. The 2010 report that you see the cover for on the left focused on federal agencies under NAGPRA, and then the report on the right, the 2011 report, focused on the Smithsonian Institution covered under the NMAI, the National Museum of the American Indian Act. At that time, we were looking at really just sort of the extent to which either the federal agencies in the case of the 2010 report or the Smithsonian museums were complying with NAGPRA. And so those 2 reports kind of give the lay of the land. They set up a nice background for each of those laws and what they do and how the review committees work. So if you're interested in that kind of information, those are good resources. And at the time, we were finding that it was a little bit of a mixed bag, and agencies really hadn't necessarily sort of come into full compliance. I think they were still experiencing a lot of challenges, and I think I shared with Shannon in our conversation and preparation, just based on what I've been hearing at this conference, what I heard in 2019 at the conference. I am heartened and hopeful that the sort of progress curve has been a little more exponential in the last 10 years than it was in the first 20. But on that note, GAO is looking to look back at NAGPRA and look at the implementation to sort of update those 2010 and 2011 reports. There is not anything formally in the works at the moment. It's still in the sort of conceptual stages. And some of the items, some of the areas that could be considered in potential future work related to NAGPRA and its implementation are an update of the federal agencies and Smithsonian's efforts since 2010 and 2011, museum efforts to comply with NAGPRA and civil enforcement issues related to that, and repatriation of cultural items that might be part of a federal agency collection or an institution collection, but are on loan to museums and educational institutions overseas. So this is an area where, because we don't have anything formally started, we're listening to what the key issues of present day NAGPRA are, and are interested in, what types of issues or areas within NAGPRA could benefit from a little bit of a deeper dive or a look by GAO. So with that, let me turn it over to Shannon.
Woo, thank you very much, Katie and Jamie. Everyone give them some love, some emojis. Awesome. And what's interesting, and sometimes I get a little bit of pushback, I'm a lawyer, but Katie's a lawyer too. But I'm a lawyer, and I always push the law, legislative change, legal change, regulation change. And I know a lot of people may get frustrated with that. But I want to give you a little bit of context. to me, the law is a mirror of what we believe as a society and what's important to us. And how we treat those laws is also a mirror of what we think of those laws as a society, right? So if we don't like a law, we will protest against it. The type of laws that get passed are the type of laws that get a lot of momentum and attention and push from various parties. And in order, the work that Katie and her law firm and the Pueblo of Acoma and other tribes have been doing to get the STOP Act passed has been taking a lot of effort to provide facts in support of why such legislation is important and supports the values of the U.S. and Congress in relation to Indian affairs. And to do that, they've had to fight other interests who don't agree with that. And when a law actually passes, you hope that the good guys have won. That's the key, right? So I want to take the information that we've talked about in an international and kind of domestic space and really talk about how we move, or what's the term or phrase, how we push the envelope, how we move the needle towards a place where that really meets the vision of the Association on American Indian Affairs. Our vision is to create a world where diverse Native American cultures and values are lived, protected, and respected. And that's what this repatriation work is about. That's what our laws should be about. Let me see if I can share. Let's see if I can do this okay. Making everyone else do it. I better be able to do it. All right, here we go. Let's see if the words will pop up. Words? Okay. Oh, that was nice. Okay. Let me go to the second page. So to me, can everyone see that? It looks a little grayish, but that's okay. To me, thank you. Changing the law means that we've got to change the perspectives of our society. And I think over the last 30 years, we've been doing a lot of work to change how we see Native American cultural heritage and how we see Indigenous peoples. So let's talk about that a little bit. To do that, we have to understand and reckon. We have to wrestle with the past. And if you were a part of our sessions earlier today about international repatriation, we were doing that with the Carl May Museum. They are still struggling with the idea that this is mine. I got this and I'm not giving it up. And then our fight against that, and part of the education to help change perspectives, change those types of perspective where this is property, this is mine, I got it, we're the conqueror. In order to change that is about truth telling. And that's all of our jobs here, attending the conference and those that do this work, is being able to tell the stories of why our ancestors were dug up with their burial belongings and how other cultural items were removed from our nations. And I hope you heard earlier, I think last Wednesday, in a session with Robert Hershey and Raymond Riley and others, where they talked about the paths that their cultural heritage took out of their dispossession, out of their possession. Our tribal histories about how our items left our nations and left our control are really important to understanding and reckoning with the past and changing perspectives. otherwise, no one has any emotional or vested interest in why this is so important to us. And as you know, if you're doing this work, we're constantly trying to support and educate others to understand and reckon with the past to move forward. We're really doing our best to make them take inventory of the work that they need to do. It's also, whoops, 2 came up for the price of 1. It's also important that we educate about what free, prior, and informed consent is. So to change the perspective of those that follow and pass laws, we need to make sure that we all have an equal playing field, right? That items that were stolen were taken without our free, prior, and informed consent. And that from here on out, exhibits, research, collection should not be happening without that free, prior, and informed consent. And we want the laws and we want the regulations to mirror that perspective. And we want to celebrate the collaborations between tribes and institutions to change those colonizer exhibits. And I want to, if you bear with me, let me, oops, wrong thing. So, and this is what I'm talking about. This is what we're used to seeing in a museum. This is a human head effigy jar, late Mississippian culture, 1350 to 1550, clay and pigment. It's a cultural, sacred, sensitive item behind glass, out of its context, away from home, away from its people, untouchable, with a simple label about who the item was purchased from. These are, I'll just flip through these. These are pictures taken from the Nelson Atkins Museum, who is also, could be argued, is not in compliance with NAGPRA, as many of the items in their exhibit are NAGPRA items and also we see similar items from the Metropolitan Museum of Art, this colonizer perspective, point of view of what our sacred and ceremonial items look like, how they should be exhibited. Here, the Metropolitan Museum of Art labels the item that it was made by a Tlingit artist. So not a ceremonial person, not a wise woman, not a chief, not a ceremonial leader, an artist, in an effort to amend our perspective of what these items truly are and to misacculturate it into an artist perspective that is not commensurate with how we look at the world. And so at the Metropolitan Museum of Art, because many of the items were ceremonial and sacred, I merely took, I'm trying to find some here, kept the labels only instead of continuing to glorify how they perceived and perpetuate our items. So this is the kind of, these are the perspectives that we are slowly learning how to remove from museums and institutions. And instead, we're beginning, after 30 years of NAGPRA and work in repatriation, we're beginning to see how the collaborations through required consultation under NAGPRA, have been developing to better rectify the problems with the colonial institutional perspective, and to really showcase proper, appropriate education for the public with the free, prior, and informed consent of the tribal nations involved. So we're seeing beautiful exhibits all over Indian country and tribal museums, as well as in partnership with other institutions who are undertaking this decolonization process, of amazing news stories that mirror our perspective. And that's because we're changing perspectives that came out of changes in the law, right? So I hope you see that connection, how powerful the law can be to change perspectives and how the world operates around us, right? And not only that, but we've seen a movement around the world that's recognizing that museums and institutions should not continue to hold items that were taken during war, violence, and colonizing. So you see the Netherlands, various, I think 16 states in Germany, and France working to repatriate items to indigenous peoples. And I want to say that Netherlands is working with Indian tribes towards repatriation. So if anyone is interested in that, let me know. In the law, so the NMAI Act, NAGPRA, and the work that's been happening over the past 31 years is coalescing to where we are today after the pandemic and the horrible things that we're learning or that we're remembering and that are getting media attention now and congressional and other attention, have brought us to a point today where we're talking about anti-racism, where these issues are at the forefront of all of our voices. Issues of boarding school research and investigation, and returning our children home from those boarding schools, and recognizing that horrible history, and the work that's going on in repatriation may not have happened without this kind of reckoning and this anti-racism movement that's in our world today. I'm just wanting to put the head or the hammer on the nail to say how important law can be to change our perception and our perspectives over time. So let's talk a little bit. I'm going to talk really fast just about some of the things that the association is doing to try to change the perspective of the world around us to make our repatriation efforts more successful. Of course, we're talking about NAGPRA. We have to talk about NAGPRA. It's really been that, in the NMAI Act has really been the work that has jettisoned these changing perspectives. Oh, regulations. So for the first time, we're finally getting a look at a comprehensive redo of the NAGPRA regulations, which were initially developed in 1995 and prior, during administration that was led by archaeologists, that was led by scientists and anthropologists in the National Park Service. They were not developed to support the beautiful language of the Act that is really simple to help, that was really meant to help support repatriation efforts. So let's talk a little bit about the regulations. There are really some important pieces of the draft regulations, as well as many tribal nation and tribal organization comments on the regulations that were provided to the Department of the Interior. And some of those issues included what it really means that Congress announced that the only exception to repatriation were where museums could prove a right of possession. What does that mean for the regulations if that truly is the only exception? The regulation draft also gave some great new purview about what compliance and enforcement could look like. We think, the association thinks, that the new regulations could be an opportunity to also address issues with boarding school cemeteries and the possibilities of repatriating children back home to their tribal nations. There's important issues of redoing how cultural affiliation is reviewed and strengthening secretarial authority. Our comments are on our website, and I hope you will read ours if I can find, where did I put them? Okay, there they are. I'm going to put this in the, I'm going to put this, if I can find the paste button. There it is. In the comments, there's Jack Trope, by the way. And our NAGPRA regulations comments are here. And I'm telling you, there's like 30 pages of comments on these regulations. These regulations are so important to help us continue to change the perspectives of how we see NAGPRA. So I hope you'll take a look at those. All right, quickly. Continuing to change NAGPRA. What about the Act? The Act still needs some amendments, even if we work hard on advocating for changes to the regulations. The Act could still use a little tweak here and there. Some of the areas that we've identified are these changes to the way civil penalties work, and whether they are mandatory versus permissive. So currently the Act is drafted to allow the secretary to, she may assert civil penalties. A good change may be to help with those incentives. Sometimes you need a stick, right? Sometimes you need carrots, sometimes you need a stick. Sometimes you need your war chiefs, sometimes you need your peace chiefs. Is to include the word shall in civil penalties, that the secretary shall enforce civil penalties with civil fines. There's also opportunities under the criminal trafficking provisions of NAGPRA to change the intent requirements. So not just increase the penalties, but currently the intent requirement in the criminal provisions, the trafficking provisions that Katie was talking about, require knowing intent, knowing that you are breaking the law, which is a really high standard to meet. But there's possibilities to change the Act and the intent requirements in the NAGPRA Act to lower intent requirements, so that there's different phased approaches and thinking of what a criminal activity is under NAGPRA. So if someone happens to be on federal lands and takes archaeological or other cultural heritage property, regardless of whether they know it's wrong or not, it should be considered trafficking and a violation of law. Also, a simple thing that can be changed in the Act currently is the definition for Native American. We know that the Kennewick Man case altered how many institutions see what Native American means, and through a simple word change in the Act that says was Native American, if we said is or was, if I'm getting that right, It would broaden the definition of Native American and potentially how institutions and agencies treat the meaning of what a Native American is. Also, I think what is important and something that the association often talks around about is expanding the jurisdictional reach of the Native American Graves Protection and Repatriation Act. We know that it only applies to federal agencies and institutions that have received federal funding or to federal and tribal lands. This is a hugely checkerboarded scheme of compliance and enforcement. We have this amazing act that declares that there are certain items that institutions should not hold because they don't have a right of possession to these items. But yet the same type of item, if a private collector holds it, they get away scot-free. And oftentimes those private collectors, dealers, and auction houses, these items come into their possession through the trade in and out of museums, academic institutions, and federal agencies. And David Barlin Lyles, during, I think it was last Wednesday, a panel that David was on then, talked about how before NAGPRA and in contemplation of NAGPRA being passed, there were federal agents that removed cultural heritage items from a national park. So many of these items that are outside the current purview of federal agencies and museums that receive federal funding got outside that purview because they were traded in and out of those institutions. So we really would like to see an expansion of the jurisdictional reach and the types of land, the status of land where cultural heritage items are found, as well as where burials are. Our cultural heritage should be seen more like air and water resources. You cannot clean air, you cannot have clean water without having a national scheme for protecting those resources. The same goes for cultural heritage. We see the same type of scheme for protecting endangered species. Or for example, the Bald Eagle and Golden Eagle Protection Act. And I say this, I talk about this many times. If an eagle dies at my house here, I'm off res, I'm on private land. But I won't have any right to that eagle or any part of that eagle, and I can't do anything commercial with that eagle. It's absolutely federally, nationally restricted that I have any access to that eagle. So should our cultural heritage and our ancestors be treated in the same manner, regardless of the status of land where they're found. So we've got a lot of work to change the perspective of how the public see what should be protected here. And let's talk about auctions. And I'm just giving you the numbers from 2019, 2020, and 2021 so far. The association does its best to look at private collections, to look at what's being sold, and make sure that our tribal partners are aware when sensitive items are coming up to the market. This is what we're fighting for, and I think changes to NAGPRA could potentially create a scheme where private collectors have to disclose what they have in their collections, and I think there's reasons in there that would be of interest to them. One is for theft. It would help protect those items from being stolen or going underground in the black market. It would also allow better understanding for tribal cultural understanding and traditional understanding, as well as scientific and academic understanding of the scope of Native American culture and what our societies have done over time. There's other important interests that I believe could drive changes to NAGPRA to expand the scope of jurisdiction to private holders. And we see that type of law in other countries where just like the Antiquities Act declares kind of a national cultural property, other countries do the same to protect their cultural heritage within their country, is declaring that kind of national protection over that heritage, so they can protect it from theft, protect it from the black market, and so that it's transparent. What else have I got going on here? Oh, that's it. So I really want the association, I really want us to be on your speed dial on these issues. Let me get rid of that. I really want us to be on your speed dial on these issues. I want to help create coalition and support so that we can continue to work to change perspectives in the public, in institutions, with folks like the Board of Trustees at Carl May Museum, with organizations like ATATA, the Tribal Dealers Association, who are working to develop their legal fund to fight acts like the STOP Act and to fight activities that the association does when we try to bring public attention to auction houses selling of culturally sensitive items. Their membership has threatened to sue us, and ATATA is actually doing auction sales of culturally sensitive and other Native American contemporary items to build their legal fund. We need to do the same. And so I'm going to put out a call to action here at the end of my thing, and then I'll call it a day for my presentation. We'll open up for questions. I want to put a call of action out there to really pull together attorneys to help build cases to support potential litigation or other negotiation and diplomacy strategies to repatriate items that are held by private collectors and that are held in various countries. I could go on and on about this, but I don't want to waste anyone's time. I know it's late. But I'm really putting out a call of action out there to attorneys and people that are very familiar with laws regarding repatriation, cultural heritage, and art crimes and art theft, to help us build a coalition and strategies to expand perspectives and protections for our Native American cultural heritages and change the law. So thank you. I appreciate your time and your attention, and I would love for you to put some questions in the Q&A. I would love for you to raise your hand and join us on stage. Love the emojis, love it so much. And I'd love to hear Katie and Jamie talk some more. I'm going to bring them up on the screen here. If I can bring, come on. Oops. Well, my cursor is not working, sorry. There we go. All right, that took some work. All right, so, well, Jamie and Katie, what do you think? What are the kind of, Jamie, I know you're, the GAO really helps with advocacy because they do research, they provide facts and study to help give the kind of information and ammunition that folks like me and folks like Katie and tribes need so we can help move the needle. And we're really looking forward to the future research you're doing. What do you think?
Well, I really appreciate you saying that because I know sometimes from our perspective, um, we can work on these issues for, a fair amount of time and then they just kind of sit there for a while. In some cases, right? Like there are certain issues that take off like wildfire and there are legislative changes made or the agencies implement recommendations right away. And then there are some areas that I've worked in where um, the work is no less valid, and it just doesn't garner the same kind of support and activity after we do it. So, from a both a personal fulfillment as well as thinking about how important the issues that we work on really are, it's really um, I'll use the term that Katie used earlier, that I was thinking about before we started our presentations tonight. It's heartening to see that there's so much activity around this, and that um, GAO can be a small contributor to the advocacy and activity or activism work that's going on, right? Because sometimes I feel like our hands are tied being nonpartisan, objective, independent. That's super important, but sometimes it doesn't feel as um, influential, maybe, as when you get to pick a side, right? Um, so to hear someone who does advocacy work and who works with tribes on these really important issues, it's important and wonderful to hear that our work is helpful. And I look forward to being able to sort of hopefully continue to work in this area and produce some more um, really good, independent, objective work that can be used by others to do what needs to be done and um, move
I
this
just
issue
want to add,
farther.
in particular, your international repatriation report. If you didn't know, it was very helpful for advocacy
Good.
on the Hill.
That's awesome.
I mean, there were some points when that report really helped us get across hurdles. So thank you.
Excellent.
Yeah. I think, Shannon, what you said before about there being, I really feel like we are getting more attention. Indian country is getting more attention than maybe we ever have or we have in a very long time. And I think that it is attention we can use to get things done. And in particular, I feel like there is a huge appetite for cultural resource work and accomplishing things in the cultural resource space. And so it makes me think a lot about this tension between like biting pieces off that you can get done smoothly and quickly, and then sort of a more holistic, what do we need, big picture. There are different strategies, pros and cons to both. I think certainly the STOP Act is narrow. It addresses one problem. But I do think that it's time for us to start really thinking about what would it look like to fix NAGPRA and ARPA, and what would it look like to do something more holistic. And Jamie, I think that you are so well suited to help us do the research to figure out what that would look like, because so many people in Indian country and advocates touch pieces of this space, but not all of it. And so we can't, each one of us can't sit down and like say, this is the universe of what needs to change. And so you're just so well suited to be able to help with that.
And I look forward to remaining part of the conversation as long as my agency will let me.
Yeah, absolutely. And it grows into American Indian religious freedom movement that came out of the 60s and the 70s and was passed in 1978. And then what happened? It lacked the enforcement. And so as advocates worked to correct that, what came out of that was the NMAI Act and NAGPRA. Those things kind of converged at that time because of the High Indian Museum changing hands. and created this opportunity for these laws, which, like I said, has jettisoned so many other things. And I think now is a time we can come back around and look at American Indian religious freedom and sacred land protection and what consultation really means when we're talking about projects that destroy our sacred places, right? So it's not just this compartmentalized idea of what NAGPRA is. I think now we have opportunities to think about what could be. What do we want this world to look like? How do we want our sacred spaces protected?
Mm-hmm. Yeah, and so coming up with sort of incremental changes, like this is what it would look like if it was great. This is what it would look, you know what I mean? Sort of strategizing around that, I think is important. I think this is a good time to be doing that and having that kind of conversation.
And absolutely, because a lot of times we just see that things happen, like, for example, when the Washington football team's name changed, it seemed to happen pretty quick. But that was activism that was going on since the 60s to get us there. If you look at school desegregation and what we understand is the Brown versus Board of Education decision that desegregated African American and white schools and amalgamate them, that came out of a lot of activism and years of work to incrementally change perspectives of the law and society to get us there. Mm-hmm. Unfortunately, we still are working on, we still got a long ways to go. But this is why it's important to understand how big we should dream and build a strategy to get us to that place. There's a few questions in our Q&A. Should I bring them up?
Yeah.
All right. So we've got Mr. David Barlin-Lyles, our new law enforcement officer and civil penalties person at National NAGPRA program. Jamie, this is for you. What is GAO's level of trust or credibility with the cultural resource protection capabilities and capacity that federal land management agencies shared with them, with GAO?
So that's a good question. I think that it varies depending on the agency. Based on what we saw, I think that all of the agencies could benefit from better information, which is why we made that recommendation in our report. There are resources and sites that likely contain resources that have not been surveyed. And I think that's, another potential topic for someone to look at, possibly GAO. I mean, it's something that we flagged, but we didn't really dig into in great detail. But we learned that, there are just acres and acres and acres of land that haven't been, they don't have the inventories, right? So how can you protect what you don't know is there? And I think that there's a really important role for tribes to play in that. I mean, the knowledge that tribes have about what's important and where that is. And I know that we heard about concerns about confidentiality and information sharing, right, between tribes and the federal agencies, and there's a trust relationship or a trust that has to exist there. But also between law enforcement components and cultural resource protection components within agencies. There are sometimes not open channels and or data sharing, because law enforcement data is law enforcement data and cultural resources data is, so there's sort of this maybe some assumptions about that. I think I had them going in when we started talking to agencies, that you talk to an agency and the agency has data. Well, you talk to cultural resources professionals and they will tell you some things, and they will tell you how they keep data and how they protect it and that sort of thing. And then you talk to law enforcement officials, and sometimes they don't talk to one another, or they share very little, and there's a reluctance to share for a variety of reasons. Agency culture plays in, and that sort of thing. So that's sort of anecdotal. It's not something, like I said, that we dug into in the work that we did on that second report, but there are definitely some themes that we were more aware of having done that work, that I do think impacts programmatically how the agencies operate. So that's another topic. One of the challenges that we have at GAO is scoping our work so that we actually produce a report in a semi-timely fashion. And if we were able to look at all of these issues that probably need to be examined, we probably wouldn't produce anything. So that's one of those things that sort of got carved out of our scope when we did that work. That again could be a subject in and of itself for some research and digging into some data. So
interesting. The 2010 report on federal agency compliance, I think it would be extremely interesting to relook at that today, because since then, a lot of universities and correctional facilities have been coming into compliance with their collections, and what they're left with are the federal agency collections. And what they have been finding is that many of those federal agencies will not allow them to do consultation and won't do it themselves. So they won't fulfill their NAGPRA responsibilities. And it seems to be weighted heavily with more the military agencies. But there are still some other agencies, like even Indian Affairs and within the Department of Interior, that are still not complying with NAGPRA. So it would be interesting to see how that has changed over the last 10 years. And then we've seen some of the worst federal agencies, like Tennessee Valley Authority, who are now just coming into great compliance and doing great work with tribes. So
I was going to say, Shannon, that was one of the things that we noticed. We weren't looking at NAGPRA compliance on the 21 report that we just did, but I had read and become familiar with the 2010 and 11 NAGPRA reports prior to doing this work, and noticed that TVA was on the naughty list of all of the agencies that they looked at in 2010. And to see what they have done and invested in making ARPA enforcement a priority they're really formalizing a lot. So it was interesting that you noted that also, because it does seem like they have sort of made a 180 shift in terms of how they are approaching it.
For sure. We have another question, and I'd really like to get Katie's wish list here from Judy. Can we talk about what a NAGPRA wish list might confront in the current congressional environment?
Well, I think that I know that there are folks on the Hill that are interested in knowing what a wish list would look like. So I think it's really important that we come together and create one. A really digestible, simple wish list with justifications. What would it look like to try to get a package like that enacted? It would be difficult. I mean, the STOP Act is so narrow, and it's been difficult and taken many years, and we would have some very, very, very staunch opposition. But I think that there are also like very interested champions on the Hill that would take this up. So I think step one is we need to create a concise, digestible wish list. And we need to meet with the folks on the Hill who are expressing interest in doing this kind of work.
Yeah, for sure. And the association and our repatriation working group have been working for several years now on what NAGPRA would look like, what amendments, if we could amend whatever we wanted to amend, what that would look like, and then what the priority amendments are. And I kind of very briefly went over what those priority amendments are or could be. And yeah, we're talking to Congress, and they're asking, how should we look at this issue and what needs to be done here? So there is some kind of willingness, right?
Oh, yeah. Yeah.
But what we can achieve, we're not too sure yet. And that's why I think it's so important, the people that have been attending this conference, and I've been looking at all your bios and your titles and your names. There are many people from the museum industry that have been a part of the conference. And we really need all of you to be ambassadors to support these kind of decolonized changes in NAGPRA and other cultural heritage law. So we'll be calling on you and asking for your help as we move forward with this advocacy. Jamie, Katie, you all are wonderful. Do you have any closing or last thoughts or things you'd like to share?
It's been really great to spend time with you, fellow panelists, and also with the audience tonight. It's good for the soul, it's meaningful, and it's really nice to be able to come together and talk about it.
Everything back.